I want to welcome everyone here to the Open Society Foundations and to this session, which is entitled Debating the War on Terror, Two Appraisals of the Obama Administration, Human Rights and Counterterrorism Policy. We are delighted to have with us here today this terrific panel, and we expect a great discussion from both Jamil and David on the Obama administration's counterterrorism policies viewed through a human rights lens. This session is going to be expertly moderated by Charlie Savage, but before I turn it over to him, I just want to make a couple of announcements. First of all, this session is being live webcast on Flora TV, and it's also being recorded. And you can follow the discussion about this panel on Twitter, and if anyone who is doing so would like to tweet a question, they can also do that at #DebateTerror. Before I turn it over to Charlie, I also want to mention that if any of you needs to take a phone call, we would invite you to use either of the rooms on the side of the conference room, which have little private spaces where you can do that. Now I'd like to introduce Charlie Savage, who will be moderating this discussion today. I think many of you know Charlie. He is a Washington correspondent for the New York Times and has been covering issues around counterterrorism and the U.S. response to the terrorist attacks of 9/11 for many, many years. In addition to his work at the Times, he was previously covering national legal affairs for the Boston Globe. And he, before that, was covering these issues at the Miami Herald in the early days, for example, covering the detention camp at Guantanamo. So we're very lucky to have Charlie with us, not only for his in-depth knowledge from his reporting and covering these issues, but he also has written a fantastic book on the growth of executive power, which is one of the main themes in this area, which is called Takeover, the Return of the Imperial Presidency and the Subversion of American Democracy. That book won many awards, as has Charlie for his reporting, including a Pulitzer Prize for National Reporting in 2007 for his coverage of presidential signing statements while he was at the Boston Globe. And that has been an important issue within this area around counterterrorism issues. So we're delighted to have Charlie with us, and I turn it over to you to introduce our speakers and kick off the panel today. Thanks very much.
Thank you, Wendy. Well, you know, a lot of these debates on national security issues tend to have a formulaic nature. You have someone on Team Republican and someone on Team Democrat, and they come and they each say that their guy had it better and the other guy is endangering national security or compromising American values or both. And that debate, though, has become a bit stale in the last few years as the Obama administration has come in and its counterterrorism policies have evolved and matured, and to a degree that was initially surprising, represented a great deal of continuity with the Bush administration's counterterrorism policies, at least as they existed by the end of 2008, since those policies, of course, evolved over the course of that 8-year administration as well. And so having someone come in from a right-wing think tank and someone from a left-wing think tank to argue about these sorts of things isn't really the debate anymore. And what's very interesting about what we're going to have today is that it's a debate from the civil libertarian perspective, maybe the left of the ledger within that spectrum as well, in which people who are maybe view themselves as more sympathetic to the Obama administration and maybe even on a personal level know more figures in that government than the Bush years, nevertheless find themselves torn, a certain ambivalence in a debate amongst themselves about what to make of how Obama has been in some ways continuing Bush-style policies, what that means, maybe what that implies retroactively about some of the rhetoric about President Bush and the previous administration as well. So in the past administration, it was hard on the right side of the civil libertarian ledger. The people at the Cato Institute, I think, were never quite sure whether they should be out throwing bombs or working behind the scenes to try to advance their point of view with their side. And since 2009, that valence has been reversed. And so it's not just a question of confusion or being pulled in opposite directions, but even of trying to figure out whether to see the glass as half empty or half full, first in that administration and now in this one. And the question has been raised in terms of political tactics. Do you engage, again, by establishing certain critical distance and strongly criticizing, or do you work behind the scenes and defend in hopes of persuading colleagues? So there's a lot of issues here that are very interesting and don't fall along the usual left-right axis to think about. And today, for the next hour and a half or so, we have two extremely distinguished people who are basically on the same team and yet find themselves disagreeing from time to time. And we're going to try to work out where there's moments of agreement but disagreement and figure things out together. So the first is David Cole. He's a Georgetown University law professor where he teaches constitutional law and national security and criminal justice. He's a graduate of Yale undergrad in law and also a volunteer attorney at the Center for Constitutional Rights, legal affairs correspondent at The Nation, regular contributor to the New York Review of Books, commentator on NPR's All Things Considered. He's written 7 books, including Enemy Aliens, Double Standards and Constitutional Freedoms in the War on Terrorism, which won an American Book Award. He's also been involved in a number of important civil liberties cases over the years, ranging from Texas v. Johnson and United States v. Eichmann, which extended First Amendment protection to flag burning, and to the case of Maher Arar, the Canadian citizen who had been rendered to Syria and tortured in the last administration. The other speaker today is Jamil Jaffer. He's the director of the American Civil Liberties Union's Center for Democracy, which houses the ACLU's work on national security, human rights, speech, privacy, and technology. Since joining the staff of the ACLU a little over a decade ago, he has litigated challenges to the Patriot Act's national security letter provisions, the NSA's warrantless wiretapping program, and the CIA's targeted killing program. He was also one of the architects of ACLU versus Department of Defense, which was the massive Freedom of Information Act litigation that resulted in the release of Bush administration so-called tortured memos and hundreds of other documents related to the abuse of prisoners in military prisons and CIA black sites. He's a graduate of Williams College, Cambridge University, and Harvard Law. He's testified before Congress about issues related to government surveillance, and since 2004, he's also served as a human rights monitor for military commissions at Gitmo. And as a fellow at the Open Societies Foundation here, he's working on a book about government secrecy and individual privacy since 9/11. So at the onset, I'm saying that I would like to point out that even though this is styled as a debate, there's going to be much on which these two speakers agree. They're obviously coming from the same team ideologically. And so I suspect that today will be one part debate, but also one part conversation, given the extension common terrain between them. And yet they have their differences, and these differences are interesting. And so I want to ask you as the audience to give them a little space, not to caricaturize them as the apologist and the complainer, because I'm also going to ask them to take on a certain degree of maybe ironic distance from their own ambivalence and try to articulate and flesh out the opposing views that can be argued, whether or not they are fully on that personally, that point of view, and as exponents of positions about which they might have personal ambivalence. So we're going to talk for the next hour and a half or so. We'll wind up no later than 2, although if things are flagging, we might wrap up a little earlier than that. And I'm going to sit down here in a second, but let me get things started by starting at the 10,000-foot level, the glass half full, the glass half empty. Could each of you talk a little bit about how you see this administration's record from the prism of continuation from the Bush administration, continuity, versus significant difference, and what to make of that record in its totality? Why don't you start, Dave?
Thanks, Charlie. And first of all, let me thank OSF for sponsoring this event and for sponsoring Jamil and I as OSF fellows this year to work on related work, and more broadly, thank OSF for supporting so many of the civil society organizations that I think, including the ACLU, including CCR, that I think have done tremendous work over the last decade plus, fighting for basic American values in the face of the threat of terror. So my view on the how we ought to assess the Obama administration is critical, but resists the claim that one often hears, very often hears, in the public at large, in the left in particular, and on the right, that Obama and Bush are essentially the same. Or, some Obama is worse, because while Bush authorized the waterboarding of individuals, 3 individuals, Obama has authorized the targeted killing of some 4,000 individuals. So really what we see is continuity, not change, despite President Obama's campaign promises. And this is a legitimation or institutionalization of the wrongful policies of the Bush administration. And while I'm hardly a defender of the Obama administration, I think that critique is greatly overstated and fails to acknowledge some really important shifts that the Obama administration brought to this subject. So many of these shifts took place on day one of the administration, when President Obama signed executive orders that prohibited enhanced interrogation tactics, ended the use of torture, closed the CIA's secret prison system of black sites into which we had been disappearing suspects for years without acknowledging their detention, without providing International Red Cross access. We have seen in the Obama administration no reports of rendition to torture, contra many such reports corroborated during the Bush administration. Subsequently, the Obama administration disclosed the previously secret torture memos and did so, as he stated at the time, in part to ensure that this practice could not be repeated. And he vowed, infamously, I suppose at this point, to close Guantanamo Bay. Those, I think, are significant differences. He also has not relied on what was, I think, President Bush's most aggressive assertion of executive power. That is the notion that under Article 2, the president, as commander-in-chief, has the power to ignore congressional and indeed judicial constraints on his actions. That argument was made with respect to the warrantless wiretapping program that President Bush had put in place, and it was also made in the first torture memo. It was also made in the Supreme Court in the Guantanamo cases that went up before the court. But the Obama administration has declined to assert that sort of ultimate power to ignore other laws. And instead, what the Obama administration has said is, we will continue to fight terrorism with all the tools that are appropriate at our disposal, which include law enforcement, but also include military measures, particularly in response to Al-Qaeda and the Taliban, which attacked us on 9/11. But we will do so within the frame of international law, the Constitution, and U.S. statutes, not in disregard of those. So whereas I think the Bush approach was characterized as an effort to avoid legal constraints, to thrust legal constraints aside, whatever they might be, statutory, constitutional, or international law, President Obama has said, no, we'll fight, but we'll fight within the frame that the laws of war give us. And I think one of the most to me, one of the most profound examples of this. Now, this is what he said in his May speech in 2009 at the National Archives about the importance of fighting for national security within the frame of the rule of law, a speech that President Bush never would have given, and a speech that caused former Vice President Cheney to do a response immediately condemning the president. So I think there's a clear difference there, but it's not just words, I don't think. And I think the best example of that is that in one of the Guantanamo habeas cases that had started under President Bush, continued under President Obama. A panel of the D.C. Circuit ruled that the laws of war are irrelevant, do not constrain the president's power to detain people at Guantanamo. And President Obama's response to that, which was essentially a gift to the president to say, look, you don't need to worry about the laws of war. We don't think they're relevant to your detention authority with respect to Guantanamo. You have this power, and you need not worry about this constraint. Now, I think you'd be hard-pressed to find any party in any litigation told by a court you have power that says, no, we don't. But you'd be especially hard-pressed to find a president who has been told by a court, you have this power unconstrained by these laws, who did what President Obama's administration did, which was to return to the court and file a brief with the en banc court saying, the panel got it wrong, we are and must be bound by the laws of war. And the en banc court then essentially relegated that aspect of the panel opinion to dicta, having no legal effect. So here's the president saying, you gave me too much power because my power must be in line with the laws of war. I think that is I don't think there's another example of a president in American history taking that kind of step. And I think we on the left undermine our cause if we disregard those significant differences for two reasons. Then I'll stop. One, because I think we're then perceived as having some completely unrealistic standard that we're imposing on the president, one that no one would ever satisfy, and that undermines your legitimacy. And two, because I think you then play into the rights argument, which is, see, Obama's doing what Bush was doing, therefore what Bush was doing was okay. And the left and the Democrats' critique of Bush was partisan. It wasn't principled, because we now see a Democratic administration doing exactly the same thing. I think that's, the premise of that argument is wrong, and I think it leads to bad consequences. And the last thing I'll say is that I do think that some of this turns on what your baseline is. If your baseline was September 10th and you think that it's not appropriate to use military force at all in response to September 11th attacks, then yes, it's continuity because President Obama is continuing to use military force to respond to al-Qaeda and the Taliban as Congress authorized after the September 11th attacks. So if that's your baseline, that we shouldn't be in war at all, then yeah, it seems outrageous that the president is killing people, the president is continuing to detain people without charge. But if the baseline is war, is September 11th happened and we went to war in response to it, and the UN and NATO recognized that as a legitimate option under the laws of war because we were attacked, then the question is not whether the president is detaining and killing, because of course the president will be detaining and killing if you're in a war. The question is whether he's doing it consistent with the laws of war or whether he's doing it outside of the laws of war and trying to push that to one side. Bush tried to push it to one side. I think Obama has tried to do it within the laws of war, although at the end of the day, I have plenty of disagreements about whether he's right on many of those questions.
So that's the glass half full overview. Jamil, articulate the other side.
Sure. Well, let me just first thank OSF too for sponsoring the event and for sponsoring David and me as fellows. I actually think one of the great things about OSF is that they tolerate and even explore these kinds of disagreements. So this I'm glad that we're doing this. And before I launch into my glass half empty spiel, I do want to just say that David is one of the people that I call for advice on all of these issues. So it's a little bit difficult to be in this position. And I agree with some of what he just said. I agree that Obama is not Bush and that there are some significant differences between the two administrations. And I think that most people on the left see that. There are things that David mentioned that I would give President Obama credit for. There are also other things that David didn't mention I would give President Obama credit for. One of them is during the Bush administration, there was this whole set of people who were excluded from the United States because of their political views. And one of the first things that the Obama administration did was reverse that set of exclusions and grant visas to those foreign scholars. So I'm not a person who doesn't give the administration credit for having made the changes that it's made. Having said that, let me now defend the view that David denigrated. I think that if we're at 10,000 feet, what we should see from there is that 12 years after 9/11, the government is engaged in warrantless wiretapping under a federal statute that gives it very broad authority to do that. It has endorsed indefinite detention at Guantanamo. Dozens of men at Guantanamo, the government says they're going to hold indefinitely without charge or trial. In part because of that policy, there are 100 people at Guantanamo now on a hunger strike. 7 people at Guantanamo have committed suicide out of despair at the conditions there. There are military commissions at Guantanamo still. It's a different set of military commissions, and they're better in many respects. But they're still military commissions, and they still share some of the character of the original military commissions. As probably all of you know, if you go down to Guantanamo to watch the military commissions, you're seated behind a plexiglass screen, and you listen to the audio feed on a 40-second delay. And you're listening to it on a delay because the government wants to prevent the detainees, to prevent the accused from testifying publicly about their torture in CIA custody. You wouldn't find that in any ordinary courtroom. You don't find it here in the United States. It's a very different system. As David mentioned, the Obama administration has dramatically expanded the targeted killing program. And this is a program, I think that David and I certainly agree with David that if you're at war, you have to accept that there's going to be a certain amount of killing. But there's a lot of distance between that proposition and the targeted killing program that's actually taking place. This is a program in which we don't know who precisely it is that the government is killing, in which countries the government is killing them. We don't know how many people the government has killed. There have been these public speeches about the program, but those speeches have focused almost entirely on high-level al-Qaeda leaders. And we know from dozens of news stories, some of which Charlie is responsible for, we know from dozens of news stories that this is a program that is responsible for the deaths of many, many people who cannot fairly be characterized as senior al-Qaeda leaders. That's the program itself, and then this is a program we know very little about because the administration has said so little about it. So, from 10,000 feet, that's what I see. I also see that nobody has been held accountable for the torture of prisoners in the CIA black sites or in the Defense Department, except for low-level soldiers. No senior official has been charged criminally or even held civilly responsible for authorizing torture, for writing the memos. And maybe that would be less objectionable to me if the administration were not at the same time so aggressively prosecuting people who exposed abuse. Some of them, on torture, but many of them on other issues. So you've got the situation where the administration is protecting the perpetrators while at the same time persecuting the people who exposed abuse. So it's a complicated question how much of that the Obama administration is responsible for. And I know that this is an event about the Obama administration and human rights, but and I will stick to that after I say what I'm about to say. But to me, the more troubling thing here and the more interesting thing than how much of this was the Bush administration, how much of it is the Obama administration, how much of it is Congress, the more interesting and important question or fact is that it's, these are the policies that are in place. Whoever's responsible for them, these are the policies that are in place. And for anybody who thought in 2002 or 2003 that these were going to be emergency policies that were here for a short period of time and that the liberties we were surrendering were going to be surrendered for a short period of time, it's got to be alarming. It should be alarming that these policies are still in place and not just still in place, but in many ways have been normalized and institutionalized. So that's to say that I do not think that Obama and Bush are the same. There are many important differences. But from 10,000 feet, what I see is that many of the most objectionable practices of the Bush administration have been normalized by this administration and in some cases expanded.
So that's a great sort of starting point, and my plan is to march through about a dozen or specific topics and dive into the weeds a little bit more. And so I'm going to start with surveillance. So Jamil, you mentioned at the very beginning, he's still warrantless wiretapping under a broad statute that gives these powers. And one of the puzzles in thinking about the question, is Obama acting like Bush, and what does it mean to act like Bush, is that we can see in retrospect now that during the Bush years, there were two different strands of critique that were sort of bound up together. There was a civil libertarian critique, the government should not have the power to do this sort of thing to individuals, and there was a rule of law critique, right, which is the president has to obey statutes. The president doesn't get to say, I'm going to disregard this law. He has to go to Congress and get it changed if he thinks the law doesn't make sense in the current context. And they were bound up together. But by the end of the Bush administration, Congress had, to use your word, normalized, on a rule of law perspective, certain issues. And among them was it enacted the FISA Amendments Act in 2008, for which Senator Obama somewhat famously voted. And this brought into alignment federal statutes with the practice of surveillance without individualized warrants as part of the war on terrorism. And so Obama has continued that program. And the question is, from a rule of law perspective, I guess things are better now because he's not violating, the president is not violating a statute. From a civil libertarian perspective, that's almost irrelevant because to protect individual rights, a judge should look at the individual and not and make sure there's a reason to be listening to that person's conversations. And these two things have come into conflict now. I was wondering if you guys could start with that. What do you make of Obama's record on surveillance without individualized warrants?
Well, I mean, I think that it's an important thing that President Obama is not violating a federal statute. He's not violating a federal statute because Congress has given him all of the authority that President Bush was claiming and more. The statute that's in place now, the FISA Amendments Act, gives the president the authority to engage in exactly the same kind of wiretapping, substantively, the same kind of wiretapping that the Bush administration was engaged in, but also gives the president the authority to engage in dragnet wiretapping of Americans' international communication. So it's a broader statute. When we complained about the Bush administration's program, and I think I speak for David here too, we complained not only that the president was violating the statute, but that the wiretapping was unconstitutional under the Fourth Amendment, that it was unreasonable because it wasn't based on probable cause, wasn't based on individualized warrants. So we had two complaints during the Bush administration, and one of those complaints has been addressed and one hasn't. I guess, I would push back on the idea that the statute was sort of exogenously generated by Congress, because the Obama administration did have a very important role in pushing for reauthorization of the FISA Amendments Act last year. So this is a statute, this is authority that the Obama administration really wanted. They are exercising authority that they wanted to have. And in some ways, an equally troubling aspect of all of this is that in the courts, the Obama administration has been very aggressive at trying to ensure that the statute isn't subject to judicial review on the merits. So it argued from the beginning that the plaintiffs who had challenged it in a case that we brought, the plaintiffs who had challenged it didn't have standing to challenge the law. They lost that argument in the Second Circuit. They asked the Supreme Court to intervene to overturn that decision so that the statute wouldn't be heard on the merits. And so, when we say that the rule of law complaint has been addressed, I think that's true to an extent. But one of our complaints back then was that the authority that the government was asserting hadn't been reviewed by any court and hadn't been sanctioned by any court, and that's still true in part because largely because the Obama administration has been so aggressive at keeping it out of court.
So, and I fully support Jamil and the ACLU's efforts to challenge the validity of the FISA Amendments Act, which the Supreme Court blocked this term by concluding that no one essentially has standing to challenge the statute unless they can identify instances in which they were surveilled, but that's a catch-22 because the surveillance is all conducted in secret and no one is informed that they were surveilled even years after the fact. And so that seems to me deeply disturbing. But I do think that the principal objection to warrantless wiretapping under the Bush administration was that there was a statute on the books called FISA that said that it is a crime to engage in warrantless wiretapping, and also provided a kind of avenue during wartime for the president to undertake emergency measures and seek congressional expansion of the law if he needed it. And President Bush simply, ran roughshod over that and authorized independently and in secret authorized a program that was directly contrary to a criminal statute. That was the principal criticism, and that is no longer true, because what we now have is a statute that provides for a certain amount of overseas wiretapping, subject to court review. So it's no longer in violation of a criminal prohibition. It's no longer secret. That is, the existence of this is no longer secret. And the president is acting pursuant to statutory authority and pursuant to judicial review. So, but it's not the kind of review that we tend to think of as necessary under the Fourth Amendment, which is individualized warrants based upon probable cause, which is an inherently individualized concept. We have reason to believe this person is engaged in criminal activity, therefore we can conduct a wiretap on this person's phone. That's not the case with this. This is about gathering foreign intelligence information, and the statute authorizes the government to do it on a kind of categorical basis. We don't really know what the categorical basis is, because Jamil's suit to try to find that out was blocked. But here's what I think the administration would say in defense of this program. They would say, look, before the sort of internet, it was long accepted that the United States could engage in unlimited surveillance of foreigners. They did it through satellites, satellite interception of conversations, and it was not regulated by FISA at all. What FISA regulated was attempts to target people in the United States or U.S. persons. If you're trying to listen in on Al Qaeda in Afghanistan, talking to Al Qaeda in the border areas of Pakistan, there wasn't any law. There wasn't a statute that governed that, and the Fourth Amendment doesn't govern that, because the Fourth Amendment doesn't apply to foreigners abroad. And so it was. So for years, the president had broad authority, unlimited by statute, to engage in this kind of categorical surveillance. Well, now in the modern era, people don't use those kind of phones anymore. That all the phone traffic goes over these internet lines, and in order to get into them, you go in through an internet service provider as opposed to via a satellite in the sky. That internet service provider is often in the United States, because we have we're the home of the corporations that created those hubs, and so technically it's covered by FISA, even though it's still you're only listening to Afghanistan to Pakistan Al Qaeda communications. And so the government said, well, we should still be able to do this, even though technically we're doing it through a U.S. hub, if our target is foreign, if we're not targeting any U.S. persons, if we're seeking foreign intelligence information, not information about an actual specific crime. In that circumstance, it's justified to say, and reasonable to say, you can listen in on all communications between, this part of Afghanistan, this part of Pakistan, or however else it's categorically defined. And so what Congress did in the Foreign Intelligence Surveillance Act amendments was to say, with respect to that kind of targeting, directed at foreigners overseas, not targeting Americans, not targeting LPRs, lawful permanent residents, not targeting anyone in the United States, even if they are a foreigner, designed to gather foreign intelligence information. If you go to a court and make all that showing, and you show to the court that you have minimization requirements in place that ensure that no American will be targeted, or no one in the United States will be targeted, and this seems critical, and the court finds that the program is consistent with the Fourth Amendment, then the court can grant the authority to engage in that kind of wiretapping. And, to me, I'm troubled by the vagueness of the categorical authority, and I'm troubled by the fact that we don't have an opportunity through any kind of public judicial system to know what the scope of that is. But I don't think that's on its face, an outrageous grant of authority to a president. It essentially updates the satellite surveillance, which we didn't challenge as unconstitutional, to the modern day through the internet. And it is true that sometimes when you're doing this, you might hear a conversation with an American, right? Because there's plenty of over-the-border conversations, and because it's hard actually today to detect where a phone call is coming from because of cell phones, because they go through these internet lines, and it's just difficult. So there is certainly a risk that Americans are going to be overheard, but the statute is designed to try to limit that risk, but maintain our authority and ability to conduct foreign intelligence surveillance abroad of foreigners.
Very quickly before we move on, Jamil, do you have any rebuttal?
Yeah. So I think David's description of the statute is quite inaccurate. I think that the whole point of the statute was to allow the government to pick up Americans' international communications. And that's not speculation on my part. That's what Bush administration officials told Congress when they were asking for this authority. They said the conversations we are most interested in are the ones that have one end inside the United States and one end outside the United States. And they did, occasionally use this smokescreen about foreign-to-foreign communications and say we shouldn't have to go get a warrant in order to wiretap somebody in Afghanistan calling somebody else in Afghanistan. But when it actually came down to it, and when others proposed, well, why don't we just carve those communications out of the scope of the statute? Why don't we just say that foreign-to-foreign communications aren't subject to a warrant requirement? Then the Bush administration forthrightly said, you know what? We really need access to Americans' international communications. And when Senator Wyden, for example, and several people proposed this, but when Senator Wyden proposed an individualized suspicion requirement. So you can get Americans' communications, but you have to have some reason to believe that somebody on the phone has done something wrong. The administration said, we can't agree to that kind of requirement because part of the point of this surveillance is to find out who it is that we should be focusing on individually. So I think that your defense of the statute on the merits is misguided, David. But beyond that, and I think this is the more important point, that you have just made exactly the kind of defense that the Obama administration could have made in court. They could have walked into court and said, this statute is constitutional for these reasons. But they didn't. And instead what they did is they said, this case has no business being in court in the first place. These people don't have a right to be here. This statute should not be challenged in this context. There is a secret court in which AT&T, if it wants to, can bring a challenge. But ordinary citizens can't challenge the government's claimed authority to wiretap their phone calls in this way. And I think that is a really troubling thing, and it's an especially troubling thing when you see it in the context of the Obama administration's many other arguments of the same nature. The torture cases, the rendition cases, the targeted killing cases. In each of these cases, the administration is walking into court and saying, this is a program that should not be subject to judicial review. It's standing in the surveillance context. They're relying on the standing doctrine. In targeted killing, it's the political question doctrine. In the rendition context, it's immunity doctrines or special factors. They always have, or state secrets. They always have something available to them. But the pattern is somebody goes into court to challenge national security policy. The administration responds in exactly the way the Bush administration responded, which is this is not an issue that courts should consider. As is probably clear, I feel especially strongly about this one because I'm the one who lost this case a few months ago. And perhaps I think it's more outrageous than it really is because I'm the one who's involved in it. But I do see this across the board. And David, you were involved in the Arar case in the Second Circuit where the same thing happened, where the courts basically said this is not an issue for the courts to decide. Even if you don't care about the civil liberties issues, but you care only about the rule of law issues, the fact that the administration is successfully keeping the courts out is something that ought to bother you.
And I would just say, I largely agree with the concern about the standing, and I think you should have won the case, as you know. But I will also say that in 30 years of litigating these types of cases, I have never seen the federal government not come in and argue that there's a standing problem, a political question problem, whatever jurisdictional defense that they can. That's just what government lawyers do under whatever the administration is, and it would be remarkable for government lawyers to change that radically. They didn't change when Clinton came to power after Reagan and the first Bush, and which is not to say to defend them, but to say I don't think it's a particular critique that is of the Obama administration. And on whether the principal concern of this statute is getting American communications, I think if the principal concern were getting American communications, you wouldn't write a statute that says you can do this only if you don't target anyone who's an American or a LPR, lawful permanent resident. You don't target anyone in the United States. You create minimization requirements that ensure that you do not, inappropriately pull up those kinds of calls. And it can only be authorized if it's consistent with the Fourth Amendment. I just think, I'm sure that I would have been happier with the narrower statute that you suggested Wyden had proposed. But I think I would take them at face value that they're concerned about Afghan to Pakistan communications. Of course, they're also going to be, if Al Qaeda is talking to someone in the United States, they're going to be concerned about that. Or why it'd be crazy not to be concerned about that, right? But the focus of the authority is on non-targeted communications abroad.
Can I have 5 seconds on that?
5 seconds.
So just I don't want anyone to walk away with a mistaken understanding of the statute. So the statute, your example, what if somebody from Al Qaeda is calling somebody in the United States? Absolutely. I think everybody agrees that kind of conversation the government has a right to listen to. But this is not a statute that requires the government to have as its target some Al Qaeda person. It can target anyone. And you're right that it forecloses the government from targeting anyone overseas. You're right, it forecloses them from targeting Americans inside the United States or anyone inside the United States if they are specifically identified. But the government can target a block of communications between New York City and London if it wants to. I don't know if they're doing that or not, but they have the authority to do it on this statute.
All right, we could obviously fill the whole time with surveillance, but let's shift to wartime detention a bit. I'd like to get your contrasting views, if they are contrasting, about indefinite detention at Guantanamo and elsewhere. One of you brought up Obama's National Archives. You brought up the National Archives speech from May of 2009, and the media framing, as a member of the media, I can self-criticize, of that was all about Obama on the left because Dick Cheney on the same day was out, and it was easy to say, here's A and here's B, and they're different. I think in hindsight, we can see that was actually a really interesting speech of Obama moving towards the center. And among the other reasons for that is that he embraced indefinite detention in that speech, even as he continued to call for Guantanamo to be closed and so forth. And it became clear at that point that closing Guantanamo, and that there would be some category of prisoners who would be too difficult to prosecute and too dangerous to release, who would be continued to be held without trial. So he made that move very fast. And in that, from the larger perspective, that was Obama saying terrorism is not just a criminal justice problem. The war it exists. It's a real war, even though it's not a nation-state adversary, and it continues. And I think a decade ago on the left, a lot of the debate and the criticism was, this isn't a real war. Al-Qaeda are criminals. There can only be an armed conflict between two countries, and all this language of war and policies of war are misguided. At this point, it seems to me that debate is fairly well settled, and this may be an example of Obama normalizing what was once extraordinary. But what do you, because closing Guantanamo would mean just moving indefinite detention to somewhere else as opposed to getting rid of indefinite detention. What do you, David, think of the record on indefinite detention, putting aside why he hasn't closed Gitmo specifically, since he, even in his own standpoint, wants to keep holding people without trial?
Yeah. Well, I think you could characterize what Obama has done as to normalize the extraordinary, but that would be to say, I think you have to be specific about what was extraordinary about what Bush was doing. And detaining people who are fighting against us for Al-Qaeda or the Taliban in an armed conflict authorized by Congress and deemed, justified by the UN and NATO was not extraordinary. That was not extraordinary. What was extraordinary was doing so entirely in secret, refusing even to disclose the names of the people who were being detained there, treating them without the dignities and respect that the Geneva Conventions require, subjecting them to torture, providing no kind of process to determine whether in fact they were fighters or not, asserting that no law protected them. That was what was extraordinary. And so, yes, Obama has normalized the extraordinary because he has now said, yes, we're going to continue to detain during war. That's normal. That's not extraordinary. There is no country that has fought a war and not detained the enemy during that war. No country in history. So that's not what was extraordinary. It was this other stuff that Bush was doing that was extraordinary. All of that is gone. Right now we have hearings, we have review, we have decent treatment. So I think it really depends on what you're. Again, this sort of goes back to your baseline. One of the kind of mantras in the human rights community was try or release. They should be tried or released. There is no room for detention. Well, that's just not right under the laws of war. That's not right. No country, again, fighting a war, has taken the position that the only circumstance in which it can hold someone who's fighting for the other side is if they can try them for a war crime. I mean, we held hundreds of thousands of people during World War II who were fighting for the other side. Maybe not hundreds of thousands. I think it was hundreds of thousands. Without trying them for any kind of crime. So this try or release mantra, I think, was just unrealistic to begin with. I don't think a sort of well thought through position. It's not one that Obama ever articulated before he came into office. Obviously, it is problematic in this case because you've got a conflict that seems to have no clear ending. We are now very far away from those attacks of 9/11. We haven't been attacked since then. At some point, the authority, I think, the armed conflict ends, and then the authority to detain should end with it. But this is not a metaphorical war on terror like the war on drugs. There is an armed conflict still going on in Afghanistan, and many of the people at Guantanamo are people who the administration believes were fighting for Al-Qaeda or the Taliban against us in that conflict. Now, there are also many people who the administration has determined don't need to be detained anymore, should be released, and those people, I think, should be released. And the only reason they're not being released is because we can't find a country to send them to. And it seems to me that, if you've locked them up, if you no longer believe they need to be detained, and if you can't find a country, that is, we can't find a country to send them to, then we should be obliged to release them within the United States. If there are people who don't pose a threat, what's the possible justification for continuing to detain them? So I think that's problematic. But the notion that someone who is properly determined to be a fighter for Al-Qaeda, the Taliban, who, if we were released, might well return to the fight against us, I think that person can be detained as long as the conflict goes on.
Jamil, do you think this is a real war at this point? Is that debate over? Legal?
Well, it depends what you mean by it. I think there is a real war going on. I agree with a lot of what David just said. I think, but all of the action is in something that David put in a footnote, which is that this is a different kind of war. And that's why we took the position that we did. It's a unique war, and it's a unique detention center with a unique history. And so with respect to Guantanamo, we at the ACLU took the position that the two options were charge or release. that wasn't meant to, and we never took the position that the government doesn't have detention authority, the kind of a detention authority you described, and that it's always had whenever it fights a war. And if the Obama administration were saying our detention authority is linked to the armed conflict in Afghanistan, then I think there would be not that much space between the Obama administration and many in the human rights community. But to my knowledge, the Obama administration has not linked the detention authority to the war in Afghanistan. They have linked the detention authority to this much more abstract war against Al-Qaeda and affiliated forces. And as you know, affiliated forces is a category that takes on a new meaning every week. And so, they're not really proposing holding people until the end of something that we could understand as a traditional armed conflict. They're proposing holding people forever. And that is something that I think is, that's something we criticized under the Bush administration. We criticize it for the same reasons now. And, I pointed to the human facts at the beginning, that there are these prisoners who are, really desperate because of the conditions that they're being held in, because of the indefinite detention they're being held in. I think that, the legal dispute is important, but we shouldn't forget that there are human consequences to the uncertainty that these prisoners are facing. Prisoners don't know when, if ever, they'll be released, and because of that, they are, literally killing themselves. So I think that there's a big difference between holding people in connection with the traditional armed conflict and holding people in the way that the administration is right now.
And I guess I think that the justification for holding people, I mean, there are 80-some people who they don't claim to need to detain. They just can't find a place to send them. And I think, I've already said what I think about that. But the other 40 are people who they believe are part of Al-Qaeda or the Taliban or associated forces, but I don't know that in any of the habeas litigation that has come up yet that there's actually been a reliance on associated forces as independent of fighting with Al-Qaeda or the Taliban as a concept. I agree that that's a troubling concept, and it's really troubling in the targeted killing area as well. And it could create the possibility of essentially resurrecting the kind of war on terror, global war on terror kind of approach. If you define an associated force very loosely, it's a very troubling concept. But I don't see that in the habeas litigation, any evidence of that. I see them making defenses that these people are, were with Al-Qaeda or the Taliban in a pretty close-knit way. And, I do think that, over time, I think, for example, that the Israeli Supreme Court got it right in saying that over time in a military detention setting like this, the burden should have to increase on the government in terms of the strength of the case it has against an individual to continue his detention. As the length of the detention grows, the certainty that this person is in fact a danger should have to grow. And so some people who were originally justifiably detained should be would at some point be released because the evidence is not strong enough. And then I also think that we ought to have a notion that we may not have ended the conflict with Al-Qaeda, but we've ended the conflict with this detainee. This detainee no longer poses a threat, and that person should then lawfully should legally be entitled to be released. So I'm not in favor of a kind of an open-ended, indefinite detention forever position, and I do think that there's a need for some serious constraints to be put in at the back end here. But as I said, I think much of the claim at the outset was that it's just wrong at the front end to be detaining someone without trying them in a criminal or military tribunal, and I think that just is not supported by the law.
If both of you seem to agree that there really is a war and was a war and continues to be a war in Afghanistan. But the war in Afghanistan will end at some point, probably sooner than later. It looks, I suspect we'll be pulling out. Karzai seems to be an unstable partner. We've turned over most of our prisoners there. David, if U.S. doesn't have troops on the ground in Afghanistan anymore, and so we're only talking about the more inchoate, no hot battlefield war on terror, do you think Detention Authority continues to exist?
My guess is the administration will certainly argue that Detention Authority continues to exist because they don't want to release those 47 people and have them, constitute a legion of Al Qaeda attacking us. But I'm not sure that is the right position. And I do think that as we withdraw from Afghanistan, it is a very appropriate time to raise anew the question of whether this problem is appropriately viewed as a military problem, as a war problem, as opposed to as a law enforcement problem. I think there were people from the outset who said that, and much of Europe will say that, right? That the United States' mistake was to go to war after 9/11. We in Britain or France or Germany dealt with terrorism as a law enforcement matter, not a war matter, and that's a better way to do so. And that's a perfectly legitimate argument. But in the United States, that was kind of a hard argument to make, right? That this is not a war, it's a law enforcement problem, when we had troops on the ground in Afghanistan being shot at on a daily basis, right? There is a sort of undeniable factual reality there that makes it hard to raise those questions. Once that factual reality is no longer exists, then I think it's certainly appropriate to ask the question of whether we are still in a situation where it's appropriate to use lethal force to respond to a problem that all nations face in some measure or another. Maybe not all nations, but many nations have faced the problem of groups of individuals who arm themselves to attack the state and its interests in the hope of spreading terror. And most of them, the vast majority of them, have not gone to war in response. And I don't think it's necessary to go to war in response unless the attack and the threat rises to a level of gravity that is akin to 9/11.
Well, let me jump in here and start with Jamil. I mean, the questions raised by the use of military force away from the hot battlefield are the most interesting to some extent. And the question of that legitimacy. What do you make of targeted killings in Yemen, for example, and whether that's sort of a preview of what the world will look like after the troops aren't on the ground anymore in Afghanistan if the war on terror continues? Mm-hmm. Is that legitimate?
Well, the government doesn't lack authority to use lethal force simply because it's not engaged in military. There are circumstances in which the government can use lethal force, even here inside the United States, right, in an ordinary law enforcement context. So to say that there's no armed conflict in Yemen is not to say that the government is without power to address threats, even in that extreme way. It's a question of what the standards are, how broad their authority is, and we have taken the position, and I'm very comfortable with this. We've taken the position that the government's authority outside active war zones is very narrow, and it's limited to the use of force against people who present imminent threats, and where the use of lethal force is a last resort. And so whether any particular strike in Yemen is lawful or not will turn on whether those that very stringent standard is met.
Of course, where the rubber hits the road on this is the administration has adopted a very elastic notion of imminence.
Right, which
you're a critic of that.
I don't share that view of imminence. I mean, that's not a view of imminence at all. That's doing. They have escaped the restriction by redefining the word.
David, do you quarrel with their claim that an elastic definition of imminence is necessary given the nature of these things?
Yeah, absolutely. I mean, I think Jamil and I are in agreement on this. Yes, there is a right to use force in self-defense to an imminent armed attack if it is in fact the last resort, as Daniel Webster said when he sort of first articulated this concept. If there's no time for deliberation, there was time for deliberation in Anwar al-Awlaki's case. He was on the kill list for a year and 3 months before he was killed. There was time to dismiss the ACLU and CCR's lawsuit seeking to save his life.
To be fair, it didn't take long.
Well, that's true. That's true. So I agree that the sort of apparently Orwellian expansion of this of the imminence criterion is very problematic. I also think the feasibility. I think the technology of drones affects the feasibility criterion. So the government says we can do it if the person poses an imminent threat, but we've defined any person who's an operational leader of an organization that has the capability and intent to attack us as posing an imminent threat forevermore. So,
but both the feasibility and the imminence criteria only come in if you've rejected the war model, right? And you're only in a self-defense world. Right. Do you reject the war model in Yemen?
Do I reject the war model in Yemen?
Yes. The war doesn't have to be infeasible to capture.
Right.
The threat doesn't have to be imminent.
No, that's absolutely right. And so I don't think anyone would object to the use of drones and targeted killing in Afghanistan. As long as we're targeting people who we have reason to believe are the enemy. And I think in the Pakistan border regions that Al Qaeda and Taliban have made their part of the battlefield, it also may well be justified as an armed conflict, not a self-defense justification. I think when you get to a place like Yemen where there is no battlefield, where we're not at war, where the group that we're concerned about is not even the group that attacked us on 9/11, it didn't even exist on 9/11, then I think you should be limited to a self-defense justification.
So agreement, no armed conflict targeting in the administration is wrong. Are you allowed to agree?
I don't know. Certainly we're allowed to agree when the administration is so clearly wrong. But the other thing I would say, though, is that we actually don't know what the administration's position on this is, right? What we know, we have gleaned. I often say, trying to figure out what the administration's policy on drone strikes is a little bit like the challenge that Sovietologists faced during the Soviet Union, where they tried to figure out what the policy of the Soviet Union was by where people were seated in various pictures of the Politburo. We're like, the whole thing is secret. The whole thing is unacknowledged. And therefore what we have are these abstract discussions by various government officials in various speeches. We have this leaked white paper that addresses one very specific instance of an American citizen, Anwar al-Awlaki presumably, and doesn't address what the criteria are for non-Americans, et cetera. We have nothing about what the criteria are for signature strikes. I mean, there's just so much that we don't know on this. And here's another area where I'm sure we agree, which is the president should not have that kind of power without it being transparent.
There is this similarity. David's not going to like this, but there is this. You remember the Abu Zubaydah memo from 2002? So this is the memo that the OLC wrote, John Yoo wrote it, justifying the torture of Abu Zubaydah. And the memo is written in a way that makes it seem like there's all this thought that has gone into the use of these methods against this specific guy in these specific circumstances because this specific guy presents a unique threat. And I was reminded of that when I read the white paper. The white paper has the same, there are many differences, but one similarity between these two things is that they are they're legal analyses relating to specific people who are thought to pose unique threats. But meanwhile, when John Yoo wrote that memo, there were hundreds of prisoners being tortured in Defense Department facilities, in the CIA, eventually in the CIA's black sites. And meanwhile, we've got this massive program, this massive targeted killing program, where there are hundreds of people, thousands of people who've been killed. And the document that's out there, is so distant from the program. There's just so much space between the program they describe in these public speeches and in the white paper and what's actually taking place on the ground. I mean, there's no mention in the public speeches of signature strikes. There's no mention of targeting anyone except for Al-Qaeda or Taliban leaders. It's not just that they haven't said very much about the program, but what they've said, by saying what they've said, I think that they have left a pretty misleading impression of what the program really is. That anyone who just focused on those statements wouldn't have any idea of what was actually going on.
Let's pivot to something. I keep looking for areas of disagreement to suss out. I'm not sure if I found one here, but if you're a critic of kill operations away from the hot battlefield of Afghanistan and maybe the Fatah region of Pakistan, what do you make of the bin Laden kill raid, both in terms of sovereignty and international law, and also whether that was he an imminent threat sitting there, or is it okay even though he wasn't?
Yeah, I don't think. I think that we don't know. To me, the thing we don't know is sort of what did he do when we came in there, and if he tried to surrender, and was there ever any intention to capture if he tried to surrender? It's clear that if the person surrenders, you are obligated to capture rather than kill, and there's certainly some reason to doubt whether they ever had any intention to capture him alive, because that would have caused more problems than having him dead. And that, but we don't know. We just don't know the facts.
Let's stipulate
on that.
he didn't raise his hands.
But I think, yeah, if he didn't surrender, I don't find it problematic to take out the leader of the organization with which you are engaged in an armed conflict when he is in a place where there really is no other option than you going in and getting him or killing him, right? He was in Pakistan. There were very legitimate concerns that if we told the Pakistanis that, we thought he was there, that people in the Pakistani government and security services would, who are loyal to him, would let him know, and he would be gone. And so it was an extraordinary circumstance. I mean, I think if we had reason to believe that he was living in some, fortified mansion in Belgravia, London, it would not be appropriate to send to send the Navy SEALs in there to attack him, because we could talk to the Brits about him, and we could presumably use law enforcement tools to capture him. But here he was, not far from the battlefield, the leader of the organization we were fighting against. And I think in that situation, it's not inappropriate to kill him, even if he's not on the battlefield and even if he doesn't pose an imminent threat. It's the same way that during World War II, if we found a leader of the Japanese or the German military flying somewhere nowhere near a battlefield or in Africa or something, there's no bar on us capturing or killing.
And does that mean you accept the administration's view that it's not a violation of sovereignty if a country is unable or unwilling to suppress a threat?
I think the unable or I can see the argument for unable or unwilling in certain circumstances as a justification for an invasion, of someone's sovereignty. That's basically what the justification for going into Afghanistan, right? They were. The Taliban, which controlled Afghanistan at the time, was unwilling to turn over Osama bin Laden and to neutralize the threat we faced from al-Qaeda, and therefore it was appropriate for us to go in there. So I can see situations in which it makes sense. Broadly construed, it seems very problematic because it suggests we'll ask you if we can come in, and if you say yes, then we can come in because you've consented, and if you say no, then we can come in because you're unwilling, and that seems deeply problematic. But if it's narrowly construed, and I think the circumstances of Pakistan were such that a strong case could be made that because of the real possibility that even raising the subject would cause us to lose the ability to capture the leader, the motivator of the fight against us, that it was justified.
Jamil, do you see anything to criticize in the bin Laden raid?
Well,
Zero Dark 30.
Right, Zero Dark 30%. Well, I agree with what David said initially, which is that ultimately there are some facts that would be nice to know that we don't know, and it's hard to come to any solid conclusion without knowing those facts. But I would ultimately analyze it a little differently than David did. I think the question I would ask first is was he participating in the armed conflict that we all recognize is going on, the one in Afghanistan? Because a lot of these border strikes in Pakistan, I think, are fairly characterized as part of that same armed conflict. And maybe there's an argument that this strike was part of that armed conflict. For example, if bin Laden was engaged somehow in directing people in Afghanistan, that would be an argument that he was engaged in that armed conflict. But if the answer to that question is no, then I think the question is, did he present an imminent threat? And I think the government would have very strong arguments that bin Laden, of all people, presents an imminent threat, not so much because he himself is going to do something, but because he has the power to order other people to do something imminently, or maybe there are even plots that the government thinks are underway. So I think that they have strong arguments, but there's a real danger in bad facts here making bad law. That, everybody agrees Bin Laden was a very bad man, but we can't start from that and then build the law around it to justify the strike. I mean, we should try to be a little bit objective about the application of the law here, and cognizant of the possibility that we create precedents, not just that other presidents, American presidents, will use, but precedents that other countries will use. And obviously, we don't want other countries carrying out targeted killings inside the United States. When Pinochet's regime carried out the killing of Orlando Letelier in the 1970s, we prosecuted the people who did that. We condemned the people who carried out the killing of Litvinenko in London. He was poisoned by the Russians in London. We condemned that. I'm not saying that the Bin Laden raid is of the same character as those, but I think that when you're thinking through what the rules are, you should think the rules through in a way that somehow compellingly distinguishes those other cases that we all recognize to have been illegitimate from the one that I think we instinctively want to think of as legitimate.
And I think it's just not that hard to distinguish them. I mean, there is a war going on. He is the leader of the organization that we are at war with. He's orchestrated attacks against us in the past and continued to have courier communications with the organization, notwithstanding the fact that he knew we were trying to find out where he was, so he wasn't as able to be effective as he otherwise would be. But the notion that you can't kill the head of the organization that you're in an armed conflict with, if you find him in a place where there's no other option, I just think that's not, you can't make that argument with a straight face. Whereas I think Litvinenko was not engaged in an armed conflict against the against Russia, and we have a ban on targeted on extrajudicial assassinations that President Ford put in place, that's still in place, and that was created because the CIA was found to be engaging in efforts to assassinate foreign leaders who we didn't like when we weren't involved in any kind of armed conflict. That's clearly wrong. But killing the leader of the organization with which you're in an ongoing armed conflict, I think that's
I agree with you that there are ways to distinguish these things. I agree with you, but I think that the way you're focused on right now, the fact that we're in an that we have declared an armed conflict against this guy, that can't be the answer, right? Because China will declare an armed conflict against its enemies, and Russia will against its
I don't
enemies.
think we just declared an armed conflict. We were attacked. 3,000 people died. The Taliban wouldn't turn them over. We then responded, and the UN said it was appropriate.
Russia will say the same thing about the Chechens, and they'll be right. There are Chechen organizations that have killed civilians in Russia. I mean, they'll have a strong argument that they are in an armed conflict with those groups. And if one of those people finds himself in the U.S. and we refuse to extradite, how are you going to distinguish it? I don't think that your distinction that we have declared an armed conflict and it is a genuine armed conflict, I don't think that's the distinction that's not a distinction that's going to make a difference in that situation. There has to be something else besides the fact that we're in an armed conflict.
Well, as I said before, I think the something else that probably needs to be there is captured by this unwilling or unable. Mm-hmm. So if there's some Chechen guy here and we're willing to do what we can to make sure that he not further a war against Russia, then Russia doesn't have any justification to come in. But if we say to Russia, we're going to let him raise billions of dollars and send troops over, and we're not going to stop him whatsoever, then I think Russia has a legitimate claim to say, wait a minute, you can't use your country as a staging ground for an attack against our country, and that becomes a justification for invading, as we did in Afghanistan.
So how about somebody like Ahmed Chalabi, who was in the United States before the war in Iraq and was trying to drum up support for a revolution in Iraq? Presumably we wouldn't have turned him over to Saddam Hussein, right? I mean, we were protecting him, we were encouraging his activities. In that situation, would Saddam Hussein have been justified? I mean, plainly not, right? Saddam Hussein would have been justified in carrying out the targeted killing?
I don't know enough about whether anything that Ahmed Chalabi was doing rose to the level of armed conflict attack on Iraq. I don't think it did. I think it involved political opposition from afar, which is very different.
I mean, we danced around this a little bit, and just to sort of hit it squarely on the head before we move on, I think part of the reason the targeted killing issues and the Bin Laden raid hit, whatever, are interesting is through the subsequent killing of Anwar al-Awlaki. Of course, you guys are both have ties to organizations that are representing his family, which makes it a little harder for you to maybe speak differently on what you see of that. But if al-Awlaki is who they said he was, do you see any principled way to distinguish the killing of him from the killing of Bin Laden?
Well,
are you okay with both?
No, I'm not okay.
So why not?
I'm not okay with both. I mean, I think that he's not even asserted to be part of Al Qaeda. He's asserted to be part of Al Qaeda in the Arabian Peninsula, a group that was formed after 9/11. So therefore, is not within the frame of the authorization to use military force, which is against those who perpetrated 9/11 and those who harbored them. If he's a co-belligerent, if that group is a co-belligerent with Al Qaeda, it gets more difficult. But at the end of the day, I think if he doesn't pose an imminent threat, then the use of lethal force is, meaning if he's not engaged in some attack upon us that leaves us no time for deliberation and means that the only way we can protect ourselves is by killing him, then I think our obligation is to wait and to take the risk that he might, by waiting, we might miss his engagement in some other plot against us in the future. But we have tremendous ability to surveil him.
And you're saying that because you reject the notion that AQIP is part of the AQIP?
Well, I don't know, and not only, I mean, I don't know enough about whether that case has been made, and they haven't had to make that case because they don't even acknowledge that they killed Anwar al-Awlaki, but also because he's in Yemen. He's not in Pakistan. He's in Yemen. We're friendly with the Yemeni. The Yemeni government is working with us. It's not at all obvious to me that he could not have been captured. From what I've read, there was one attempt to capture him, and it failed. But we knew where he was going. I mean, he was driving in a car from one spot to another spot when we killed him with the drone. Presumably, if we shared that intelligence with the Yemenis could have come in and, instead of using a drone to kill him, could have captured him. So I just don't see the case. I mean, the administration itself says that to justify the killing of Anwar al-Awlaki, he had to pose an imminent threat, and then they redefine imminence in a way that I think is unacceptable. And I just don't see that he posed that threat. And I think when you're talking about the leader of Al Qaeda, the actual group we're fighting with, not some associated force, and you're talking about him being, in a country where the actual armed conflict is going on, Pakistan, not that far from the hot battlefield. I think that's quite different.
Wish I could disagree.
I mean, you do acknowledge that AQIP repeatedly tried to attack the United States as well, right?
Yeah, I acknowledge that I've read reports. I don't have any actual information, but I acknowledge that he's said to have been behind the December underwear bomber attack, and also a cargo bomb attack that was both of which failed. But I mean, there are also a lot of people right here in the United States who have been charged and admitted to engage, attempting to engage in armed attacks, right? If you call them, I think the term armed attack is problematic. Terrorist acts, right? Blowing up bombs in Times Square or the Herald Square subway or Seattle Christmas tree lighting, right? And what do we do with respect to them? We arrest them, we try them, we convict them, and we lock them up for that crime. And I think that's the presumptive way to deal with terrorism. And what worries me about the whole associated force, the looseness of associated forces, and the ease of killing with drones is that I think it tips the balance and makes it very, very tempting for the government, when it could use law enforcement means and intelligence means and other means to resolve problems of terrorism, to treat those problems as war problems. And so I think it's really critical that we have a very stringent sort of definition of what level of armed and organized attacks upon the United States justify a military response, and I think that 9/11 and the embassy bombings meets the criteria. I'm not sure 2 attempts failed, meets that criteria, and I think it's dangerous to have the criteria be, as some have suggested, any attempt to kill an American. Then you can go to war. Then you can use a drone strike. Then you don't need to arrest, try, etc. And that's where I worry that we may be going.
All right, so we have about half an hour left. I'd like to start taking questions, starting with a few that I think have come in over Twitter, and then any in the audience.
So we know they're short questions.
Yes.
We have to respond in 240 characters or whatever it is, right?
140.
140. Oh.
Okay. This is from OneCade. David Cole says he doesn't oppose taking out the leader of a group if you can't capture him. Does this apply to Obama? I'm not sure. That's sort of a provocative question.
Well, I think in wartime, can you, in a traditional war, could we kill Hitler? Could they kill FDR? I actually don't know the answer to that, but probably yes, but I don't know the answer to that. But certainly you can kill the leader of the army in a war, and Osama bin Laden was effectively that.
All right, Jamil.
That was 130. That was 139.
No
characters.
expertise to add.
Yeah. Wait, here's an interesting tactical question. This, I guess.
But I guess I think that maybe what the question is getting, and I think that this worries both David and me. It's right now we are really the only ones who have this technology, and so it's very easy to adopt relatively broad rules, relatively lax rules for the use of the technology, because we know we're the only ones who are really going to be able to use it. But it's only a matter of a year or 2 years or 3 years before half a dozen other countries have the same technology, and they'll be able to carry out the same kinds of strikes we're carrying out right now. And my impression is that the Obama administration is really thinking about tomorrow. They're not thinking about next week or a month from now. They're thinking about tomorrow. And maybe they're thinking about the rest of their term. They're not thinking about the next president, how the next president's going to use this power, or against which enemy the next president's going to use this power. And they're definitely not thinking about how is China or Iran or North Korea or whatever it is, going to use this power. And I feel pretty confident that 5 years from now, a lot of the people who are now in the Obama administration are going to regret that they didn't put clearer and more stringent rules in place for the use of these things.
This is a tactical question, and it goes to the extensive contacts that members of civil society groups like yours have with Obama administration officials, the personal ties, the ability to pick up the phone, to get briefings, and so forth. Do you think that's a net positive or a net negative? Would the groups be more effective at more of an arm's length from this administration in achieving their goals? Have they been co-opted, in other words?
Well, nobody returns my phone call, so it's not an issue with me. But I do think this is something that I'm sure Dave will disagree with. But I do think that there is real inconsistency amongst some in the human rights community and many Democrats in their criticism. In their criticisms over the last decade. I mean, it is inconceivable to me that we would have accepted this targeted killing program had it been introduced by the Bush administration. Inconceivable that we would have been as complacent as we seem to be about it right now. And that's not so much because civil liberties and human rights groups have been co-opted. It's because a lot of the people who would have been on our side, Democrats, are unable or unwilling to criticize the Obama administration on this set of policies. So maybe that's not an answer to your question, but
I guess I don't see a lot of acceptance within the civil society groups of the drone policy. I think that's actually been there's been fairly consistent criticism of it. I think it's a plus and a minus, right? I mean, when President Bush is in office, the ACLU and CCR's coffers get filled. It's good, it's good for business. You have someone that people are scared of. People see and understand the real need for civil society organizations to fight against this. What we saw after 9/11, because nobody else was, and I think they were right to do that and right to support those organizations. And I think those organizations actually played a big role in the curtailments that we saw even during the Bush administration and in the further curtailments that we've seen under Obama. On the other hand, when the Republicans are in power, it's very hard for anyone in the sort of human rights community even to get in the door, to walk in the door, to be heard by the executive branch, and that's less true with the Obama administration. And there are people whose sort of framework and viewpoint on the world were framed by their human rights and civil society experiences, who went into the Obama administration. So but it's also tougher to sort of attack Obama because people are less afraid of him. So it becomes a more complicated. The advocacy, I think, is in some ways easier when you've got a clear enemy than when you've got someone who's a friend but you think is doing the wrong thing in various institutions, but various incidents. But at the end of the day, I would certainly rather have my friends in there, even if they're making mistakes, than have President Romney or President, some other iteration of President Bush.
Do you think that some of obviously both of you still are involved in these issues, but it is undeniable that there's been a muting of interest? The right doesn't really criticize Obama for these policies, with the exception of a stray Rand Paul type figure. The left is much quieter than it was during the Bush years. There's certain years, you say your group's coffers aren't being filled. Does that, you raised at the beginning that your remarks that there's this sort of right-wing meme that it was all partisan, and actually the continuity shows that, there was nothing wrong with what Bush did. You laid out your view that there's actually significant differences, and what's wrong is changed. But to some extent, does the continuity, especially that someone like you see, Jamil, suggest that in retrospect, some significant percentage of the criticism during the Bush years was opportunistic, partisan?
Oh, absolutely, yeah. I misspoke earlier, actually, when I said that the civil liberties and human rights community have been muted. I didn't mean to. I actually don't think that's true at all. The civil liberties and human rights community, I think, have been great on the drone issue. But had this happened 5 years ago, we would have had a lot of Democrats on our side, and there's some overlap between Democrats and the civil liberties and human rights community, just as there is, on the Republican side. But if this were happening under President Bush, we would have all of these Democrats on our side, and we don't have all of these Democrats on our side. Sometimes we do have some of them, but I wish that we had them more than we often do.
Yeah, but we'd have Dick Cheney on the other side, and instead we'd have Joe Biden.
Yeah.
The other thing you said that was interesting was that the civil side, the protests and the lawsuits and so forth that groups like yours brought during the Bush years, you thought deserve a lot of credit for, fixing problems and so forth. Jamil, do you share the view that these groups, including your own, deserve a lot of credit for, solving problems?
I certainly deserve credit. Right. Well, I don't think there's a lot to take credit for. I think that, as I said at the beginning, I think that things have, as is now obvious, I'm not a glass half full person on this set of issues. I think that we're on a very dangerous course, and we have made small adjustments to it over the last few years, but they're small adjustments, and I think it would be healthy for the civil liberties and human rights community to think about why it is that we haven't been more successful at shifting the government's direction on this set of issues. And if you compare, so I'm Canadian myself, and I see how Canadians react to some of the national security policies that the Canadian government has put in place. And up in Canada, the name Maher Arar is a household. Everybody knows it. Everybody knows who he is, and everybody knows what happened to him. And most people read the report, the official government reports about his treatment. And down here, I think there's still there isn't that familiarity with the facts, and I think that people in the civil liberties community are right to be, are right to think about why it is that we haven't been more successful down here at getting this set of facts into the public consciousness and changing the direction of the government. Now, I'm not saying that, I'm glad these organizations are around. I wouldn't be doing the work that I do if I didn't think that the ACLU were an important organization actually making a difference. But, I think that there's less to celebrate than I think David does.
And I guess I don't necessarily want to be celebratory here or have rose-tinted glasses, but I think one can acknowledge that the toughest time, right, to defend rights is when the government is taking rights from foreigners in a war who are said to be the enemy. Right, that is the toughest time to defend rights, and historically in every nation, that is the case. It's not anything unique to the United States. And so after 9/11, when we were locking up foreigners here and at Guantanamo, when we were rendering people foreigners to be tortured and the like, in Canada they know who Maher Arar is because he's a Canadian. It reminds me of the Andy Borowitz report on the poll, which found that 97% of Americans are opposed to being killed by a drone. If it's us, if it's our rights, then we're concerned. But but by and large, the victims are not us; they're them, and that's a really tough situation. And so the Congress wasn't pushing back against President Bush. The court only pushed back in fairly minimalist ways. The American people weren't pushing back against President Bush. They reelected him, and after we went to war in Iraq. But nonetheless, over time, Bush was forced to curtail virtually all of his most aggressive policies. And where was the resistance? I think the resistance came from civil society organizations, from some parts of the press, which played a big role. What would we look like today if the Center for Constitutional Rights had not brought the Rasool case, if Reprieve had not sent Clive Stafford Smith out to every country that had a person at Guantanamo to do press conferences, to put pressure on their governments, to put pressure on our government, leading Bush to release 500 people from Guantanamo. People sometimes forget that. He didn't do that voluntarily. He did that because of pressure created by civil society, putting pressure on foreign governments to bring pressure. Where would we be on torture if the ACLU hadn't brought the FOIA lawsuit that disclosed so many of the torture documents? Where would we be on cruel and human degrading treatment if Human Rights First had not organized the former generals to stand up behind John McCain and deliver the biggest defeat that the Bush administration faced from Congress in its entire 8 years on the issue of cruel and human and degrading treatment of foreigners abroad? So I think that is something that we should be proud of, and no, we haven't succeeded to the point where we would like to succeed, but that just means we have to keep fighting.
Okay.
So I was actually going to ask about
A microphone is coming your way. Maybe. I can always repeat. You got it.
Ask about our responsibility as advocates to educate the public and the press on where we really are on these issues, given the intense amount of interest that the world shows in what the U.S. government is doing and not doing. And the example, it seems to me, I agree with David on we've made a lot of progress. I think that if you look at John Kerry's acceptance speech when he was nominated, and he says, when I'm president, John Ashcroft is not going to be my attorney general. that was an amazing recognition. He was talking about, because I'm not going to have a civil liberties person, a person who doesn't care about civil liberties as the Attorney General, and that was directly the result of civil society pressure. It was not the result of some senators, you know. Right?
But he didn't say Jamil Jaffer would be Attorney General.
No.
That's what we want.
Well, he didn't, right. Right. But so Charlie, whose reporting is wonderful, but starts off this discussion with indefinite detention, Obama moved to the middle, and when you all talk about it, it turns out that, Jamil, you agree that there are situations where it would be legal to detain people by the military until the end of hostilities without charges. I think David's description of the way it's understood publicly is right, though. It's understood that the civil liberties community believes in try or release. That's not the position that my organization took. We, before 2004, filed amicus briefs saying law of war detention for an indefinite period of time is legal in certain circumstances. And that what we have happening at the moment is the Obama administration trying to bring back the limits of law of war detention to what is traditionally understood and accepted as law of war detention.
I don't think that's true, Kate. I mean, I don't think that the Obama administration has said that at the end of hostilities in Afghanistan, these 48 people are going to be released.
No, they haven't answered the question. 2 lawyers for the Obama administration have raised the possibility that they may well have to be released. And you can't, I mean, I wouldn't even want them to say right now, oh, as soon as we leave Afghanistan, they have to be released, because the only effect of saying that publicly at the moment will be that Congress, as soon as you can blink your eye, will say, you better not release them. But, you know, I think that issue is clearly open within the Obama administration. It will be raised in the habeas litigation as to whether or not, when the war is over in Afghanistan, hostilities authorized by the AUMF are finished, and what do we do about that then?
Do you have also a question to throw at them?
Well, so my question was, in a situation where the issues are really complicated and the changes are really complicated and legal, et cetera, what do you see our role in trying to educate the press and, other than Charlie, the public, who are not too interested in the nuances of these issues and are happy to talk about try or release, indefinite detention, and Bush and Obama being the same as Bush? And doesn't that in itself make the protection of human rights more difficult worldwide if the understanding is Obama is the same as Bush?
To Jamil?
Well, you know, I guess I'm not willing to take responsibility for the fact that the world thinks Obama is the same as Bush. I mean, that's not something I've ever said, and you know, we try to give the administration credit where they deserve credit, and to criticize them where they deserve to be criticized. It's just that I think they deserve more criticism than David does. You know, on this try or release issue, I don't think that our position was so nuanced that it, you know, that it wasn't digestible by the ordinary public. Our position was Guantanamo is a unique place. This is a unique kind of war, and in this context, we think try or release is what makes sense. I don't think that's too complicated, and I still think it was the right position and is the right position. When I say that we recognize that the government sometimes has the authority to detain somebody until the end of hostilities, I'm not talking about Guantanamo. I'm making a general point about, you know, for example, in Afghanistan, they can hold people until the end of hostilities in Afghanistan. But with respect to Guantanamo, because of the history of the place, the history of those people, the fact that this detention center is halfway across the world from the armed conflict, the fact that so many people were tortured in custody, the fact that they were detained not in connection really with that armed conflict, but instead in connection with the global war on terror. For all of those reasons, we thought that try or release was a policy that made sense, and we still think that's the policy that made sense. But as I said earlier, you know, if the administration comes to the conclusion, or if the courts force the administration to come to the conclusion that people at Guantanamo who have been detained over the last decade have to be released or tried at the end of the hostilities in Afghanistan, I think that would be a huge step forward.
Why don't you just stick the microphone where you will?
Thanks. My question is more about, I guess, the 10,000-foot level. When we're talking about the power to torture or kill, the Bush torture memo logic was, if you can kill the enemy, then you can waterboard the enemy, and by the way, waterboarding is not torture. And then Obama said, you can't torture, and waterboarding is torture, but you can kill the enemy in certain circumstances, but it's unclear what they are. All of this was decided at the time, and then secret memos written by the executive branch. And it's just been changed by the executive branch in more secret memos. And so isn't there a concern, regardless of whether or not there are differences, but isn't there a concern that the law has just become whatever the president decides it is?
The critique of Office of Legal Counsel, executive branch lawyering. My favorite topic in the world, actually. Not kidding.
You should respond.
Yeah.
I think there's a concern.
Oh, you maybe so, because we're running out of time. All right.
Yeah, all right.
OLC lawyering, still a problem. Go ahead.
Yeah. My name is Li Yang. First, I would like to have this panel, and maybe with a cooperation with the Department of Justice and the President, whether Bush or Obama. I think what they are doing is practically they do about the same rather than difference. And because once they got elected, they just campaign everywhere without really looking into the problem behind them or their supporters doing the wrong things. You see that the Department of Justice never prosecute anybody. And Obama is always listen to his supporter or where the money come from. The real civil liberties issues or human rights issues really don't really come out on the top of the issues. So I just wonder whether there is a, the Iraq, they didn't allow him to speak. And they killed Osama bin Laden without even produce a body. So we don't know exactly what's going on. And then the people are not really informed. Voters, every day, election after election, they don't know who they're really voting for. All they do is they heard the propaganda by the special interest group. And they get the money, bail out everything from them. And the department say they are too big to prosecute. And what I would say, the department is too corrupt to prosecute anything. So all this differentiation, and they don't listen to people anyhow.
Okay.
If you have anybody who want to speak, they silence you down. So I think Obama really had to say something, and Department of Justice, whether Eric Holder or anybody else, because if you don't listen to the people, and if you don't bring up the issue up front, and always a mess.
All right. So failure of the Justice Department to prosecute people. She talked about banks and moneylenders, but also gets into your torture and look forward, not back. Last question.
So my question has to do with this idea that the Obama administration may be continuing some of the same policies, but it's doing it within the law, and it's not claiming the right to ignore the law. And I don't think that's insignificant at all. But I do think the significance is somewhat diminished when you have a Congress that's willing to grant you any authority you want, essentially, even if it's of dubious constitutionality, and you can prevent the courts from reviewing the constitutionality of that law. So to me, that somewhat weakens the significance of, okay, one of these administrations is acting within the law. But even beyond that, and this is really my question, there are two ways to get around a law you don't like. And the Bush administration did the belt and suspenders approach. It redefined the law in a way that it was breaking the law, but it just said it was an interpretation of the law through OLC. And it said, and if that doesn't work, we have the authority to disregard the law. The Obama administration has decided it doesn't need the belt, but it's kept the suspenders. So we have this definition of imminence that makes a joke out of the law of war. And we have interpretations of FISA, which we only know a little bit about thanks to reporting, but that some senators who know more than we do have said that it makes a joke out of FISA, the way that the administration is interpreting it. And that's across a range of different applications of FISA. There is some good evidence that's building up that the government is engaging in bulk dragnet collection of even domestic communications on the idea that somehow it's okay if they don't actually look at it until later. So there are some interpretations of the law that are going on under this administration that really do skirt the law. And what's the difference between doing that and saying, oh, and also we could just ignore it? I mean, I'm not saying there's no difference at all, but I just think it's a simplification. It strikes me as a simplification to say that this administration is committed to operating within the law. And I think, to me, it seems like a better interpretation to say, well, they're getting most of what they want from the law, and when they're not, they're just interpreting it differently. David, do you think that's wrong?
Yeah, I mean, I think, all law, as we learn in law school, as we teach in law school, there's lots of room for interpretation of all laws, and nowhere more so than in the area of national security is that the case for a variety of reasons, some good, some bad. But I guess I think there is a fundamental difference between an administration that takes the position that law should be thrust aside and treated as an obstacle, and an administration that says we should operate and we must operate within the law, and the law gives us a variety of options, and we're willing to defend our actions within that concept without resorting to claims that law doesn't apply. Geneva Conventions don't apply. We put people in Guantanamo, law doesn't apply there. Habeas doesn't apply there, right? The FISA doesn't apply because it's Article 2 commander-in-chief power. That kind of argument, I think, is fundamentally different from an attempt, albeit flawed, as far as I can tell, to figure out how the laws of war, which permit killing in two contexts, armed conflict and self-defense, should be applied in this in a situation that they really didn't contemplate when they were drafted, namely non-state actors that are in various parts of the world that are difficult to police and that have the capability to attack us with very grave consequences. It is to some extent a new world, and you have to take laws that were designed to deal with older problems and apply them to this new set. But I think they're trying to apply them. I don't think they're asserting we don't even have to apply them. And that's the basic Bush approach was we don't even have to apply them. Sure, within the law there's lots of things you can do in a war. But that was one of my critiques of the Bush administration from the beginning. They had the right to detain people who were fighting against us at Guantanamo or anywhere else they wanted to detain them, as long as they did it pursuant to the laws of war, recognized Geneva Convention's protections, didn't treat them inhumanely, and the like. And they threw all that aside and created this problem that they didn't need to create. So I do think there's a big difference. On secret law, I think secret law is a problem. And I think it's deeply problematic that very, very important powers like the power, what power could be more important than the power of the executive to kill American citizens and refuse to acknowledge that he has done so? That's the power that they have asserted with Anwar al-Awlaki. That can't, in a democracy, that can't be secret. And so I think there's a real problem with secret law, which was a huge problem in the Bush administration, but it continues to be a problem under the Obama administration.
That's a good exit thought for you. Jamil, you want to take a minute or two and sum things up in response to these questions and the general discussion?
Well, so I think that the last question was, gets to something that well, I think that is exactly right. That the distance between ignoring the law and reinterpreting the law is, sometimes not that great. And in the Anwar al-Awlaki case, what the government did is they interpreted the AOMF very, very broadly. And so they went into court and they said, Congress has authorized us to carry out these kinds of strikes. And we went into court and we said, that's not what the AOMF didn't authorize you to kill American citizens in Yemen who aren't associated with Al-Qaeda. And their response was, well, the scope of the AOMF is a political question to be decided by the political branches, and the court has no business weighing in on it. all other things equal, I think it's a good thing that the Obama administration uses the language of law to explain their actions. But sometimes the way that they're doing it is troubling for other reasons. So, and then on the secret law issue, I think this is probably something that all three of us agree on. There's too much secrecy around a lot of these issues. One of the things that a lot of people have forgotten is that the Obama administration very early on said that they would do a review of these FISA court opinions to determine what could be released. And recently, Stephen Aptergood, who's sort of the guru of secrecy, made some calls in the Obama administration to figure out what had gone on with that inquiry. And essentially, the answer is nothing, that they've decided that nothing can be released. And we see that across all of these issues, on surveillance, on targeted killing, on interrogation. The administration they were very good on this in the first 6 months in 2009, but since then they've really closed the tap, and on national security issues, it's very difficult to get anything out of the government.
Take it away.
Terrific. Well, thank you so much, Jamil and David, for a discussion that was both lively and illuminating, and I think really helped us to think hard about important questions around the rule of law and the human rights and civil liberties implications of many different aspects of counterterrorism policy. You covered an impressive array of issues in a short amount of time, and for that we particularly want to thank Charlie for facilitating such a terrific discussion. So I also want to thank all of you for coming today, and please join me in thanking our panelists.